The only people who don't want to disclose the truth are people with something to hide.
That kind of leads us into the case that I really wanted to talk about tonight, that now that you're no longer on the bench, you were doing re-election in 2010, as I understand, so you've been in private practice since then, I believe. Is that correct?
Yes, that's right.
Okay. And you became involved at a fairly late stage here in a case called Jordan v. Reed, which was followed by Linda Jordan. And how did you hear about that case?
Well, she called me up on the phone. She said that she was in trouble, that she had brought a case against the Secretary of State back last August to try to keep President Obama off the ballot. And she lost her case within a couple of days. It was dismissed. She appealed it to the state Supreme Court. Nobody really was interested in hearing her case on the merits. Rather, the court then dismissed her case as frivolous, directed the clerk of the court to assess an award of reasonable attorney fees against her, and hit her with a $13,000 award. And at that point, she'd had enough of representing herself and came to me. And I discovered that the Attorney General, who had sought the $13,000 award, never told the clerk that he had actually charged the Secretary of State about $3,500 for the representation, but yet he had obtained an award 3 or 4 times that amount. So that was one of the main talking points that I had in trying to set this award aside. It's still pending. I think we're going to be able to do it, but it's not over yet.
Let's talk a little bit about that. I know we talked just before the start of the show, and you said that you weren't there at the beginning of the case. Now, I listened to another radio show where Ms. Jordan was on. I want to go into the details, some of the details. I want to go into the details of the case. First, she said she asked 8 attorneys to take her case originally, and they all refused. Do you know why they refused?
That's right. She said that she went to numerous lawyers to try to get some help, and they turned her down. I guess that they were worried about being labeled as birthers or out there, and thought of some of them said that they just disagreed with her politically and wouldn't represent her. But that's not my attitude at all. I think that if people can make a reasonable deal about paying their lawyer, that I'm happy to represent them if I can, and I don't really care what other people think about me. That's not my problem. That's their problem. I'm here to try to bring justice to the individual.
Okay, but do you think her case is filed was frivolous, the original case?
Well, the reason she lost is that the Secretary of State took the position that he had gotten a certification from the National Democratic Committee that Barack Obama and Joe Biden were the nominee for president and vice president, and the Secretary of State took the position that under the laws of the state of Washington, that's all he needs to know, and that it's not his prerogative to go beyond or behind that certification to determine whether or not the candidate is actually eligible to run. So, I don't know whether he's right about that or wrong about that, but that's the position that he took. So I think that these cases have usually been losers in the end, and there were a couple on the East Coast where the court fined not only the litigant but the lawyer like $20,000 for bringing the case. So I think we have to be pretty careful about this and make sure that the claim has an ability to get relief on the theory that you bring the claim. So I don't know what that theory would be, but apparently the Superior Court in this state, as well as the state Supreme Court, thought that there was no way that a claim such as the one that she brought could obtain relief even if she was correct.
Well, here, apparently the judge was persuaded by the Attorney General's argument because he said, I'm persuaded by every defense raised by the Secretary of State. And the main points of the case were that she failed to name an indispensable party, which was the President Obama, that the court lacked subject matter jurisdiction because it's not the Secretary of State's job to determine the President's eligibility, and that your Ms. Jordan misconstrued the law on what the Secretary of State had to do. And as a matter of fact, he concluded, and he said, I can conceive of no reason why this lawsuit was brought except to join the chorus of noise in that blogosphere. This case is dismissed. That pretty much sounds like the judge thought it was frivolous, doesn't it?
Yes, right. He did. He did think it was frivolous, and that's what he did.
So you really didn't answer my question. I assume you've read some of the earlier papers in this case. Do you think it was frivolous?
Well, look, I think that Linda Jordan brought this case in good faith. I don't think she could get from here to there in the context of this case. If that's your question, I think that she thought the merits of her claim through. I think that she had evidence to support her claim, but that she could not surmount the situation where that it was out of the Department of the Secretary of State to, even if he believed it, to stop Barack Obama from being on the ballot. And I think that was the central problem here in this case.
Okay.
Although, beyond that, I mean, let's be honest about this. No matter what the context of the case, if the court heard it on the merits, and she would come forward with her evidence, and if the court ever ruled in her favor or the favor of anybody else taking a similar position, that would be catastrophic. It would upset the apple cart, and the system is not going to permit that to happen. And that's the sad, the sad reality of our current situation.
Well, let's talk about her evidence. Did she have any admissible evidence?
Well, I think that the thrust of her argument and her evidence was that Barack Obama's birth certificate was forged. And she had some declarations from individuals who purported to be experts on that who testified that they thought it was forged. So that was her evidence. But like I said, it kind of goes to a point that the Secretary of State said didn't matter as far as what his job was.
Well, what do you believe? Is President Obama eligible?
Well, personally, I'd like to see some evidence, not just a negative type evidence saying that there's a problem with his paperwork, but rather some positive evidence showing that he was actually born someplace outside the country, where he was born, when he was born, what the circumstances were, and I haven't seen that evidence.
So you believe he's eligible then from the evidence you've seen?
Well, I think that the people that believe he's ineligible have a ways to go to prove their case, because you can't just prove a positive by demonstrating a negative. And that's now I know that there are individuals listening to your program who haven't answered all of this, and maybe they do. I mean, maybe they're right. I'm not an expert on this, but in this regard, I'm a layman, and that would be my question. How do we prove where he was actually born?
Well, I think it's pretty easy. He produced 2 birth certificates, that were valid. The short sworn birth certificate that the birth was made such a hickhack over is a perfectly legitimate birth certificate. If a sealed birth certificate were presented before your court with no evidence to the contrary and with a letter and a verification from the state saying that it's valid, wouldn't you tend to accept it as valid?
Sure.
Okay. We're all in agreement there. This is not a birth, in case you haven't figured out, this is not a birth radio show. And we actually believe in the full faith and credit clause in the Constitution. There's a reason it's there. So good. So you've seen no evidence at all that he wasn't born in Hawaii. And while we're talking about that, we'll get back to the case in a minute. Let's accept as a fact that he was born in Hawaii, because I think most reasonable people would conclude that. Don't you agree?
That he was not born in Hawaii? Or
no, that he was born in Hawaii in 1961.
Well, I that's my assumption. I guess there were a couple of notices in local newspapers at the time, so in Hawaiian newspapers of the birth. So you've got to go some to overcome that, it seems to me. I
agree. Now, by his birth in Hawaii, in the fact that he's 35 years old, and that he was a resident of the country 14 years before running for president, then he's eligible, correct? If those points are all correct.
Yes, yeah, sure.
And I take it then you don't buy into the birther theory that's being pushed lately, especially with the emergence of potential candidates like Marco Rubio and the Senator Cruz, that you do not have to, it doesn't matter, your parentage doesn't matter. They're putting this theory that, and it's actually been adjudicated in some of these birth cases, that both of your parents have to be citizens or you're not a natural born citizen. You don't buy into that, do you?
No, I don't, but I don't claim to be an expert on this either.
Okay. Well, I've read quite a bit about it, and we've had two presidents now who only had one parent as a citizen, Chester Arthur and Barack Obama, and it really was never even brought up when Obama was a candidate. It was only brought up after the election.
They are not near Baghdad. Don't believe them. They are nowhere. This is silly.
The only people who don't want to disclose the truth are people with something to hide.